Judge Robert Satter, a trial judge in Connecticut and author of a new book called Doing Justice, a trial judge at work. What's the worst part about being a judge?
Worst part about being a judge?
The worst part.
The worst part, I think, at the moment is the crush of criminal cases, which makes much of what a judge does somewhat irrelevant. Specifically, I mean that there's such a crowdedness in the courts, in the jails these days. There's such an overcrowdedness that for every person put into jail, prison, somebody has to be let out. And as a result, sentences that judges impose are simply not served. In Connecticut, 1/10 of a sentence is actually served before a person is let out because of the overcrowdedness of the courts. So I'd say, I guess the most frustrating aspect of being a judge is not having one's own decision, one's own sentences carried out.
How long have you been on the bench?
15 years.
How did you get there? Elected, appointed? How'd it go?
Appointed as a consequence of being involved in politics in the state of Connecticut.
Why did you write this book?
I wrote the book in order to understand the experience.
Of writing a book? Or
No, of understanding the experience of being a judge. I had, as every judge does, heard case after case after case, and I just wanted to get a hold of it and put the experience in some coherent form. I remembered the line of Socrates that an unexamined life is not worth living, and I just decided that I better examine my own experience. And so I wrote the book to understand what I was doing.
Well, what's your conclusion after writing the book?
My conclusion after writing the book is that what I suspected as I was going through the experience is that a judge has a vast discretion in deciding many, many cases, and who the judge is makes a big difference. The judge is part of his judgment, not in all cases, of course. In questions where the law is fixed, the judge follows, the trial judge particularly follows the law. So there's a clear statute. The trial judge likewise applies the law. But there's a vast amount of discretion in the administration of the law from the judge's point of view. And I found that it made a difference who I was in making the decisions that I made. Other judges might not have made the same decision.
Are you a different kind of judge now than you were 15 years ago?
I don't think so, really. Maybe I've changed. Maybe other lawyers could say I've changed. I think I had a pretty firm handle on what I was about before I became a judge. I'd been a lawyer for a number of years, for 25 years. I'd been a legislator, and I'd had a lot of experience in the courts. And so I came to the bench with a pretty firm conception of society and of human nature.
Do you think it's possible to be named a judge at too young of an age?
Yes, by all means. Terrible mistake for a person, certainly a person before 40 becoming a judge is, I think, a mistake in his life. You should be more involved in the community. A judge is very much out of the community. He can't be involved in so many of the affairs of society. And it's a big shame to deprive oneself of that experience by becoming a judge too early.
Yet we've had some Supreme Court justices who are younger than 40.
I know that. Well, I suppose the Supreme Court, you take that becomes your career, but I think for the average person, if he had his choice as to when he would like to become a judge, if he knew he could become a judge at a certain age, I would suspect that most people would feel they should be close to 50 before they became a judge.
How old were you when you became a judge?
I was 55.
What's the most common myth about being a judge?
I guess the most common myth about being a judge is that a judge has only one choice to make. He must follow the law, and the law is inexorable, and his job is to just find out what the law is and put that imprint on a case. That, I think, is the most common myth.
What's the truth?
The truth is that a judge has a lot of choices. That, again, I say sometimes the law is very fixed, but other times even the precedents differ, and the judge has a right to make a choice of what precedent he's going to follow. Sometimes the issue is right at the edge of precedents, and a judge can decide which way he wants to go. And in many other kinds of cases, like our court hears all the civil and all the criminal cases that a traditional Superior Court case, but in addition, our court hears family cases, hears juvenile cases and housing court cases, and as a consequence, there's a vast amount of discretion we can make in deciding cases that involves people's lives very directly.
In the book, Doing Justice, you've got a whole chapter devoted to the general notion of how you decide a court case. And would you talk a little bit about that and citing some specific examples?
Yes. First of all, there's a general conception that, as I guess I said before, that judges have to just find out what the law is, and when they find it, they apply it. The legal realists say that judges don't consider themselves with the law at all, but they just simply come to a conclusion where they want to go and then find principles to justify their decision. The truth is probably halfway between. There are some cases where the law is certain, as I've said, and the law applies it. There are other cases that are in between. There are other kinds of cases like equity cases, cases where the judge simply has to be fair. For example, a case in which a judge has to decide whether to order specific performance of a contract. Specific performance is an equitable remedy, and the judge has a right to just decide what is the fairest thing to do under the circumstances. And in those kinds of cases, the judge's values very much come into play. A judge's experiences come into play, his life's experiences come into play. In a case involving a specific performance question, a black person was seeking to buy a home from a white couple which had decided at one moment to sell the house and then had reconciled and decided to continue to live together and decided not to sell the house. And so the black person sued for specific performance. And the white couple said, listen, we made a mistake. Give them whatever damages they've suffered, but don't kick us out of our own home, which we've lived in for a number of years. And the question came, what is the fair thing to do? My own life's experiences had been that I had once, in that very town that was involved in this case, had represented a black person who had sought to buy a house in the town and eventually felt that the only way he could buy it was to have somebody else act for him. And he didn't even appear at the closing, so nobody knew that he was a black person buying the house. I appeared and I handed him the deed, and he was delighted that he had the house. Well, that experience, there was a life experience that very much affected my decision in the case of the black couple buying this house in the case before me. I decided that it would be much harder for that couple to ever buy a house in that town. They had a contract, and I felt the fairest thing was that they should get the house, and so I granted the specific performance. But the decision was based upon my own life's experience.
And you could have easily gone the other way?
I could have easily gone the other way, and another judge might have gone the other way.
Was there a epilogue to that story?
There was an appeal to the appellate court, and the court affirmed it.
You are a trial court judge.
Yes, sir.
That means there's always somebody looking over your shoulder. What is your thinking when you're deciding, knowing that there's a state Supreme Court that could overturn your decision?
Well, trial judges are always aware of that, and it requires that they apply the law. They can't be freewheeling. They have to apply the law when the law is positive and clear, and even when it's not clear, you seek to guess as to what the Supreme Court will do on the situation. No judge wants to be reversed. On the other hand, you can't be so constricted with concern about reversal that you don't try to reach the right result in the given case and hope that the Supreme Court will see it the same way as you would. And so you're aware of it. You're upset by the fact that sometimes you're reversed, but that's the lot of a trial judge.
Don't take this question wrong, but it comes from your book, which I read last night. Do judges have to be pompous?
No, they don't have to be, but it's part of the judicial malady to be inclined toward pomposity.
What leads judges to pomposity?
The fact that everybody is obeisant to them, the fact that everybody calls them judge or your honor on and off the court, even on the tennis court, the fact you start to think you're pretty important, and some people can't resist them.
You've got an interesting portion of the book that's devoted to the effects of speaking on the record all the time.
Well, that gives rise to the judicial malady of ponderousness. When a judge everything a judge says in court is on the record. It's in a transcript. And anybody who's ever seen a transcript of what he says has got to be humbled. There's all the fractured syntax, all the split infinitives, all the incoherences. Even this very tape, if it were printed, would be embarrassing probably the way, maybe, well, I'm not talking, I'll impose it on you. So when a judge realizes that everything he says is going to be on the record, he speaks more slowly, and he sounds ponderous.
Do you see much poor advocacy in front of you?
Some, yeah.
How do you as a judge respond when you see an obviously inadequate presentation, either a defense or a prosecution?
Well, that's a hard thing to do something about first. I mean, a judge is presiding over what is called the adversary system, where the truth is supposed to be revealed by both sides putting on their case without the judge intervening. When a judge does intervene on the side of an incompetent lawyer, he is weighting the scales against the other side because the jury is listening. And if a judge intervenes and seems to be implying he's in favor of another side, it's unfair to the side against whom he's speaking. So it has to be done carefully. On the other hand, sometimes it has to be done. I mean, you just justice cries out for the question being asked that the lawyer has not asked, that you know should be asked, and you anticipate will give the answer that will make a difference in the outcome of the case. And judges do it. I do it. I do it carefully, but I do it.
What kind of law did you practice before assuming the bench?
Well, I practice primarily labor law and trial law, and I did a lot of administrative law before state agencies.
How did your professional life change moving from practicing lawyer to donning the robe?
Well, it changed a lot, really. I mean, I had been a member, I had been the senior partner in my law firm. I had partners, I had secretaries and associates, and I had a convivial office, or thought I did. And we had a lot of fun. I enjoyed my clients, and I enjoyed the freedom of going and doing whatever I wanted to do. I was off to Fenway Park whenever I had an urge to, or down to Forest Hills to see the tennis match. As a judge, the first and most important shock I had really was the loneliness of the job. Sent to a town fairly far from where I lived. I didn't know anybody in town. There was nobody to have lunch with. I had lunch by myself, which was a very strange experience. When I left the courtroom at the end of the day, there was nobody to say goodnight to. I went home to my home and worked on my opinions in lonely isolation. And that was a shock to me. It took a long time to get used to that.
You take a pay cut?
Sure did.
What do you think of that?
Well, I did it. I mean, at that point in my life, I was anxious and ready to be a judge, and the pay didn't make that much difference, but I sure did take a pay cut.
But it makes a difference to some judges, doesn't it?
It makes a difference to my children at that point were in college, but almost out of college. But boy, these younger people in their 40s who have children in college, it is a terrible strain on them.
What should we do about judicial pay?
Well, I think nobody should be denied the opportunity to serve on the bench because of pay, and I think the pay should be commensurate with the responsibility. I mean, I think that the federal judges have they had their pay raise yet? I never know where they are on that.
A little.
They've had a little, and state courts are always behind the federal courts. I think the pay should be commensurate with the job. I mean, it's frankly, it has been the case that the large law firms in New York hire young first-year, hire people just out of law school and pay them more than many judges get in this country. I mean, a $65,000 a year salary paid to a law school graduate is not the amount that many judges get in the United States.
In your book, you make several suggestions for court reform, such as personal injury awards. Let's talk about some of those suggestions.
Well, I do have one suggestion about that. I think that the real difficulty that I have with the civil jury system, we're now talking about personal juries giving verdicts in personal injury cases, is the erratic quality of those decisions. The same injury gives rise to a verdict of $20,000 or $40,000 or $120,000. There's no rationalization of jury verdicts on injuries. And lawyers know this. It results, quite frankly, in why cases are settled, because defendants just don't want to take a chance with jurors. But the basis for the jury erratic decision-making on verdicts is that they really, A, they don't have any experience. B, they don't get any help from the judges. The judge tells the jury in a personal injury case, when it comes to damages, you're to award fair, just, and reasonable compensation. He can say that over 20 times, but isn't going to tell the jury anything. And thirdly, and most importantly, jurors don't know what the parties really want in the case. The result is their verdicts are as erratic as lottery numbers. I think that a personal injury case should be tried first by a determination of the liability. Is the doctor negligent in the treatment of his patient? Has the defendant been negligent in the operation of the automobile, etc.? When the jury decides the question of liability for the plaintiff, or the person bringing the action, the evidence should be put upon the damages. What has the plaintiff suffered? What's the nature of the injury? What's the consequence of the injury on the plaintiff's life, etc.? At the end of all the evidence, the judge should call the two lawyers into his chambers and say to the plaintiff, all right, what do you want? What number do you want to submit to the jury? You want to submit to the jury as what you think the evidence reveals to be fair damages. And he may say $100,000. And then the judge should ask the defendant what he thinks. And the defendant may say, well, I think the evidence is not going to give any more than $50,000. And then the judge should say to the lawyers, all right, do you want to change either of your numbers in light of the other's number? Because the jury's only going to decide one number or the other, not in between. So if you think, Mr. Plaintiff, that you're too high, they're going to choose the defendant's number. And if the defendant is too low, you're going to choose the plaintiff's number. So eventually, maybe they'll come a little closer to the middle. And then they should argue to the jury. The plaintiff saying, having reduced his number, I think, Mr. and Mrs. Members of the jury, you should pay my client $80,000, and this is the reason, pointing to a specific number. And the defendant should say, the case liability having been established, should pay $60,000. And they should argue to that. The jury should choose one or the other. The consequence of that is that whatever verdict the jury comes back with, it's going to be a rational number that both parties have essentially established as what they think is the fair value of the case. And you won't get the $150,000 case or the $1 million verdict that nobody expected.
You also have some suggestions about jury instructions.
Well, jury instructions first of all, it's an art. The judge who gives an accurate statement of the law read from previous court opinions may be accurate from the point of view of the appellate court, but may not be communicating much to the jury. So that a court instruction on the law to the jury, in my judgment, should be clear, should be accurate, but it should also be clear in as close to layman's language as it can be, retaining its accuracy. But I also think that judges' instructions to the jury should be in writing.
They're not now?
They're not now. They're not in most states. I don't believe they're in the federal courts either. The result is the jury hears a judge expound on what the law is, that the jury itself is to apply to the facts in reaching a decision. And they have hard either A, understanding it, or B, remembering it when they're in the jury. Having it in writing would enable them to ponder over it and I think, apply it better.
Why is it a suggestion for reform that the jury should be allowed to ask questions? It sounds like an obvious suggestion.
It's not allowed in virtually any state, although it's getting to be allowed. There's a recent experiment made by the American Judicial Society to allow judges permit jury to ask questions, and I've participated in it, and I've done it even before then. It's a wonderful thing. I don't know why the lawyers oppose it. The lawyers think that their trying of the case is being invaded. But how wrong they are. If a juror has a question that he wants to ask of a witness because there's because the witness hasn't made something clear. Why isn't the lawyer delighted with that so he can have that matter cleared up? Or bring in other evidence to answer the question in the juror's mind? Why let the jury sit there as sphinxes without any idea what goes on in their mind and what doubts have been created by the case? I'm very much in favor of juries being allowed to ask questions.
What about the effort, especially on the federal level, for sentencing guidelines? Does that remove too much of your discretion, or don't you care?
Oh, I care a lot. That's, first of all, discretion in sentencing is let me state it another way. The variety of sentencing based on the individual judges is very great. It's dramatic. We, in a lot of states, in Connecticut, for example, we have sentencing seminars where the judges will get on one piece of paper all the facts about a given case, the nature of the crime, the facts about the defendant's background, etc. And then they're asked to give an opinion. In Connecticut, in these sentencing seminars, the suggested sentences vary all over the lot, from probation to 10 years on any given crime. So that variety of sentencing, disparity in sentencing, is a significant fact in the administration of the criminal justice system. The federal courts have adopted strict guidelines where the sentencing judge is required to give a certain sentence based upon certain standards and can vary it only by a relatively small amount. Some of the federal judges seem restive under that. We don't have that in Connecticut, so I can't really tell how it works. My concern only is that while I believe there should be uniformity of sentences because it's a quality of justice, a sentence should not be dependent on before whom a defendant happens to come. At the same time, I don't think all discretion should be taken from judges because there are individual circumstances that require individual judgment.
Child custody cases. You have any thoughts about those?
None other than they're very, very hard. I mean, dealing with a person's lives, with people's lives. And the court listens with a lot of anguish to the testimony on both sides and tries to make the right decision. I had a case, I'll just tell you briefly about it, in which a woman had a child before she was married, and her mother was so upset that he wouldn't let the mother come home, so the mother married the father of the child, a very unhappy marriage. And the woman came out of the marriage and again wanted to take the child home with her, and her mother wouldn't allow her. So she gave up custody to the father and her husband. 5 years later, her life changed, and she had remarried and now was living in a very nice home in a suburb of Hartford and wanted the child back. In the meantime, the father had himself been raising the child, remarried, and was raising the child, and the child was a very happy little boy. A very hard decision on that question. In the end, I decided to let the child stay with the father. But when I left the courtroom, I was told by the sheriff that the couple embraced, and they had sort of accepted my decision. And I felt good about that.
Do you sometimes have trouble sleeping at night over some of the decisions you have to make?
Before making it.
Mm-hmm.
Before making a decision, I agonize over it. Think about it all the time. When I have a tough case, think about it in the car driving to the courthouse. I think about it when I'm shaving. I think about it when I'm having dinner with my wife. And I think about it all the time. And eventually, I come to a decision. And the decision I come to, I always want not only think right, not only to be rational and based on rational reasons, but also to feel right, to feel it hits right within me. And then when I decide it, it's over with. I never rethink my decision.
Never?
Well, one case I rethought. There was one case that was a troublesome case. A man had been, was charged with unlawful restraint and robbery of a woman, and the woman had not been able to identify him in a police lineup or in police photos. But in the courtroom, she readily identified the defendant who was sitting beside his lawyer as her assailant. Courtroom identifications are notoriously unreliable. The defendant, in his defense, said that he was at He was at a family party, and 5 members of his family testified that he had been there. The jury, after a very swift deliberation, came back with a conviction. They found the man guilty. I didn't think he really was guilty, and I really believed him. He sounded truthful to me on the stand, and his 5 members of his family sounded truthful to me. But the jury had found him guilty, and I had to sentence him.
You have no discretion to overturn a jury verdict?
Not on a factual question. The jury had a right to believe the woman who identified him, and I did not have any right to overturn that. So I had to sentence him. I had to sentence a man that I didn't think was guilty. I got the pre-sentence report, and it showed he had committed a number of other crimes, one of which had been exactly like that, for which he had previously been convicted. So now I had a man with a record, a substantial record of violence, whom I had to sentence, and whom I did not believe was guilty of the crime. But it was the judgment of the jury, not mine, and so I sentenced him. But that has always been a troublesome case to me.
What advice did you receive when you rose to the bench?
I got one piece of advice. An old wise judge told me, always put your robe, never put your robe on over your suit coat, and always go to the bathroom before going on the bench. And that was the sum total of advice I got.
If you were advising a brand new judge, let's say a 45-year-old man or woman, what advice would you give?
I would say to him,
read my book.
Yes, read my book. I would say to him, have courage, have confidence in your own internal feelings, your own gut feelings. Try to do justice. Struggle to find the right way to solve a problem which the law seems to be against you. If you can find a valid way to do it, then do it. Don't break the law, don't deviate from the law, but use the law to achieve justice.
Who do you hope and expect will read this book?
I hope lawyers will read it. I hope judges will read it, because I had a colleague tell me the most wonderful thing about that book. He said, after I read your book, I didn't feel so lonely again. I realized that what you were trying to do was what I've been trying to do. And I hope the lay public will read it in order to understand how our system works.
What tone does the book take? What style?
Well, I hope it takes the style of trying to make it clear. I hope its style is one of clarity. That's what I struggle to achieve.
Is it your first book?
Yes.
Is it your last?
I hope not.
What do you think of when you think about the next book?
Well, I've written a book about my careers as a lawyer and a legislator, and I'm going to try to make that into a book, using the style of this book, using the examples, the way I did in this book, to make it more interesting.
Well, thank you. Judge Robert Satter, we appreciate your time.
Yes, sir. Before I became a judge, I'd been a lawyer for a number of years, for 25 years. I'd been a legislator, and I'd had a lot of experience in the courts. And so I came to the bench with a pretty firm conception of society and of human nature.
Do you think it's possible to be named a judge at too young of an age?
Yes, by all means. Terrible mistake for a person, certainly a person before 40 becoming a judge is, I think, a mistake in his life. You should be more involved in the community. A judge is very much out of the community. He can't be involved in so many of the affairs of society. And it's a big shame to deprive oneself of that experience by becoming a judge too early.
Yet we've had some Supreme Court justices who are younger than 40.
I know that. Well, I suppose the Supreme Court, you take that becomes your career, but I think for the average person, if he had his choice as to when he would like to become a judge, if he knew he could become a judge at a certain age, I would suspect that most people would feel they should be close to 50 before they became a judge.
How old were you when you became a judge?
I was 55.
What's the most common myth about being a judge?
I guess the most common myth about being a judge is that a judge has only one choice to make. He must follow the law, and the law is inexorable, and his job is to just find out what the law is and put that imprint on a case. That, I think, is the most common myth.
What's the truth?
The truth is that a judge has a lot of choices. Again, I say sometimes the law is very fixed, but other times even the precedents differ, and the judge has a right to make a choice of what precedent he's going to follow. Sometimes the issues not having one's own decision, one's own sentences carried out.
How long have you been on the bench?
15 years.
How did you get there? Elected, appointed? How'd it go?
Appointed as a consequence of being involved in politics in the state of Connecticut.
Why did you write this book?
I wrote the book in order to understand the experience.
Of writing a book? Or
No, of understanding the experience of being a judge. I had, as every judge does, heard case after case after case, and I just wanted to get a hold of it and put the experience in some coherent form. I remembered the line of Socrates that an unexamined life is not worth living, and I just decided that I better examine my own experience. And so I wrote the book to understand what I was doing.
Well, what's your conclusion after writing the book? Judge Robert Satter, a trial judge in Connecticut and author of a new book called Doing Justice, A Trial Judge at Work. What's the worst part about being a judge?
Worst part about being a judge?
The worst part.
The worst part, I think, at the moment is the crush of criminal cases, which makes much of what a judge does somewhat irrelevant. Specifically, I mean that there's such a crowdedness in the courts, in the jails these days. There's such an overcrowdedness that for every person put into jail, prison, somebody has to be let out. And as a result, sentences that judges impose are simply not served. In Connecticut, 1/10 of a sentence is actually served before a person is let out because of the overcrowdedness of the courts. So I'd say, I guess the most frustrating aspect of being a judge is, my conclusion after writing the book is that what I suspected as I was going through the experience is that a judge has a vast discretion in deciding many, many cases, and who the judge is makes a big difference. The judge is part of his judgment, not in all cases, of course. The question is where the law is fixed, the judge follows, the trial judge particularly follows the law. So there's a clear statute, the trial judge likewise applies the law. But there's a vast amount of discretion in the administration of the law from the judge's point of view. And I found that it made a difference who I was in making the decisions that I made. Other judges might not have made the same decision.
Are you a different kind of judge now than you were 15 years ago?
I don't think so, really. Maybe I've changed. Maybe other lawyers could say I've changed. I think I had a pretty firm handle on what I was about.